الحمد لله رب العالمين والصلاة والسلام على رسوله الأمين وعلى آله وصحبه الطيبين الطاهرين. أما بعد، فإن أصدق الحديث كتاب الله، وخير الهدي هدي محمد صلى الله عليه وسلم، وشر الأمور محدثاتها، وكل بدعة ضلالة. ثم أما بعد، أيها الأحبة الكرام، السلام عليكم ورحمة الله وبركاته. Inshallah, today I will talk about two topics. We're going to talk about al-wasaya, which is wills in Islam, and also we'll talk about al-ariya, which is lent items. طيب, al-wasaya is a plural of wasiya, and wasiya in Arabic means a will, and it is a contract that comes into operation after the death of the testator, the death of the musi. Here in this contract, which is the will in Islam, we have the testator, which is called al-musi, the one who is bequesting or writing the will is called the musi. And the recipient of the legacy, or the recipient of the property or the bequest, is called al-musa lahu. Al-musa lahu. And the executor of the will is called al-wasi. Al-wasi is the executor of the will. And if you remember, we said there are four terminology regarding representation in Islam. We have al-wakil. Al-wakil is the agent or the representative of someone. Any person can assign or appoint a person to be his representative in performing or conducting contracts, including even a marriage contract. A wali can delegate someone or ask someone to represent him to perform the marriage contract on his behalf. This is called wakil. We have an-nazir, and an-nazir is the manager of the waqf. Remember the waqf? Endowment. If someone donated a property that to be retained and the proceeding of it to be spent for a good cause, he can assign or appoint a manager. This manager is called an-nazir. Al-wali. Al-wali is the representative of the bride in a marriage contract. And usually he is the father or the grandfather, of course, if the father is not available or if he's not qualified, and brothers and sons and so on. It's called al-wali. And here we have al-wasi. Al-wasi is the one who execute the will of the deceased. And al-wasi, of course, he does so after the pass away of the one who wrote the will. So generally, the will is a contract that comes into operation after the death of al-musi, the death of the testator. The will be executed after first paying all the debts owed by the deceased, including the debts of man or the debts of Allah, like if he did not pay the zakah. So it has to be paid first. Now, if that individual wasn't able to make Hajj, then Hajj should be made from his wealth, the wealth that he left behind. So if it costs, for example, to appoint someone to do Hajj on his behalf, if it costs for $5,000, then it will be deducted first. So the debts, including the debts for people and the debts of Allah, like zakah and Hajj, it will be deducted first. Then after that, the wasiyah or the will be executed. After the deduction of all the rights of man and the rights of Allah, then whatever left from his legacy, it will be, first the wasiyah will be paid, and then the rest would be distributed among his heirs. The will could include the following. First of all, bequest or like properties or wealth to be distributed or given to some person or to a school or a masjid. Also instructions, like for example, he can give instructions that after my death, this and this should be done. Like for example, assigning rights, like he can assign someone to be the guardian of his kids. He can also include this in his wasiyah. If there is dain or debt that is unknown, there is no witnesses for it, then also he has to mention it. It becomes an obligation for him to write a will in this case. If someone owes money to other people and maybe no one know about that, his heirs are not aware about that, then he has to write a will in which he should instruct his heirs to pay off the debt from, of course, from what he will leave behind. So all those things could be included in the will. In generally, the legal status of will in Islam, that is recommended. But it becomes an obligation if there are rights upon the deceased. He has to write everything. Okay? All other people's rights should be included in this will. It becomes an obligation. Okay? كما جاء في حديث النبي صلى الله عليه وسلم الذي أخرجه الإمام البخاري حديث عبد الله بن عمر قال ما من حق, if someone has rights to other people, it is not allowed or permissible for him to spend 2 nights without having his will written down beside him. Okay? So if there are people's right, he has to write a will. But if there is no rights for people and he wants only to donate money to a good cause or to a person, then it is recommended for him to write the will. Of course, the will, like any other contract, could be in a written form or it could be verbal. It could be verbal or in a written form. But if it is verbal, then witnesses are required, according almost to all the scholars. Witnesses are required if it's a verbal. If it's written, according to the Hanbali madhab, that there is no need for witnesses, as long as that person's handwriting is known or signature is known. Okay, but combining witnesses and writing, it will be much better because this will authenticate that will more. Okay, now in case if there is argument or dispute about whether this is his handwriting or not, of course this would be judged by a judge in a court of law. Okay, but in general the will could be in a verbal form, providing that we have two just witnesses. Just witness means Muslim, trustworthy Muslims. Okay, and also in al-wasiyah, the testimony of non-believers is accepted, providing at the time of death of that person there is no Muslim around him. So in that case, the testimony of disbelievers is accepted. This is the only exception, okay, to accept the testimony of non-Muslim, because one of the basic conditions of a witness is to be just, and being just means that to be a Muslim first, then trustworthy, and the rest of the conditions for being a witness in Islam. طيب. So the witnesses were mentioned in Surah Al-Ma'idah.
يا أيها الذين آمنوا شهادة بينكم إذا حضر أحدكم الموت حين الوصية اثنان ذوى عدل منكم.
يا أيها الذين آمنوا شهادة بينكم إذا حضر أحدكم الموت حين الوصية اثنان ذوى عدل منكم. So in this ayah specifies that at the time of death, if someone wants to make a verbal wasiyah, a verbal will, then two just witnesses are required. طيب. Those two witnesses, of course, whether it is written or verbal, they need to know the content of the wasiyah, according to the majority of the scholars. The Maliki position here that they do not have to know the content of the wasiyah. as long as, for example, he handed them, or he said, this book contains my wasiyah, without looking into it, it's acceptable according to the Maliki Madhab. As long as we know this is the book, or that is the wasiyah written by that person, without knowing the content. But for the other three major schools, they said the witnesses should know the content of the wasiyah. What are the conditions for the testator, the one who writes or gives the wasiyah? Of course, some of those conditions are common for all the other types of contracts. For example, legal competence, that he should be an adult, sane, mature. Okay, when making the will, the testator must be, of course, in sane mind, and must not be under compulsion. He should do it willingly, without being forced to do it. He or she cannot bequest more than 1/3 of his wealth. Now, this is a requirement. He cannot exceed 1/3 of the wealth, except with the approval of his heirs. He cannot donate any part of his wealth that's more than 1/3. The maximum he can, or he has the right to bequest, is the 1/3, and the 1/3 is too much. The Prophet ﷺ directed Sa'ad ibn Abi Waqqas not even to give the 1/3. He said, وَالثُّلُثُ كَثِيرٌ, is too much. 1/3 is too much. So the lesser the amount given bequested in the wasiyah is better. Abu Bakr as-Siddiq was mentioned that he preferred not to exceed 1/5 in the wasiyah, to leave some wealth to his heirs. So he should not exceed 1/3. There are some exceptions here. Now, if this person does not have any legal heirs, like he passed away, he does not have sons, no wife, nothing, no one is going to inherit him. If that is the case, he can donate all his property or his wealth, for example, to a good cause like a masjid or a hospital or a person. This is one exception. Another exception, that if the only legal heir is his spouse, like if a person passed away, say the husband passed away, okay, so the wife is entitled to 1/4 if he does not have any legal heirs other than the wife. Okay, so she entitled to get 1/4. So he can donate it the 3/4 in his will. He has that right now. Okay, this is also another exception. But in general, if he has people who will inherit him, he must not exceed the 1/3. This is the fourth condition. This is the third condition. The fourth condition, that he cannot give any part of his wealth as a bequest to any one of his legal heirs. He cannot bequest anything to anyone who is entitled to inherit him, like a son or a daughter, or a wife, for example, or a brother, if those are entitled to inherit him. He cannot do that. Some people, they use some tricky ways. Like, for example, if he favors one of his daughters, okay, he might bequest some of his wealth to her husband. Her husband is not one of his heirs. But if we found out that he did that because he favored this daughter over the other daughter, this becomes illegal and it should not be executed. Okay, because he's benefiting his daughter through, a tricky way. It's called hila. It's unacceptable. Okay. For the recipient of the bequest, of course, he must be in existence at the time of the death of the musi. Like if the recipient, the one who was mentioned or bequested or mentioned in the will, passed away before the testator, of course, the wasiyah becomes invalid. So the condition here that the musi, the testator, must pass away, must die before the recipient of the wasiyah. Okay. Of course, he should not, as we said, he should not, or she should not be among his heirs. He must, the recipient, he must accept or reject the bequest. Okay. And this is also a third condition for the recipient, that he must accept or reject. He should say, okay, I accepted this bequest after the death, of course, of the Musi. Okay, now, if he failed to accept or reject, or if he passed away before accepting or rejecting, according to the Hanafi, now the wasiyah should be executed, and that money or that wealth should go to the recipient heirs. Okay, but according to the majority, they said, no, we don't pass the wealth to his heirs, we pass the right to accept or reject to his heirs. Is it clear? Like if the recipient, it's a condition that he should say, I'm accepting the bequest, or I'm rejecting it. If he said, I reject it, then it goes back to the heirs of the deceased. If he said, I accept it, of course it becomes his. But if he failed to either accept or reject, and he passed away before accepting or rejecting, according to the Hanafi, they said this considered to be like acceptance, and this wealth should be passed to his heirs, to the heirs of the recipient. Okay. For the majority of the scholars, they said, no, we don't pass the wealth, we pass the right to accept or reject. It goes back now to the heirs of the deceased recipient. They can either accept the will as a bequest or reject it. For the person who writes the will, he can change his mind any time, of course, before the death. He has the absolute right to change his mind before his death, because this contract will not be executed unless the deceased the person is died. So as long as he's still living, he can change his mind, he can change his will, he can write another will, he can reduce the amount or increase it, or add other people, other recipients. It's up to him. Okay. Also, as I said, if the recipient dies before the testator, then the wasiyah become invalid. This is the unanimous consensus of all the scholars. Now the executor of the will, al-wasi, of course has to be a Muslim, and he has to be just, trustworthy, adult, sane. All the conditions, all these conditions of legal competence should be applied to him. And there are different types of execution. The testator can give him a specific wasiyah, like just guardianship of his kids, but doing nothing with managing their wealth. Or he can give him full guardianship, like to take care of his kids and also manage the wealth that they will inherit from him. As long as he specified a specific task for that wasi, then the executor should just follow the wishes of the testator. This in general, the basic rules of wasiyah, of will in Islam. As for not to include any of his heirs in the wasiyah, this is based in the hadith of the Prophet ﷺ, إِنَّ اللَّهَ قَدْ أَعْطَى كُلَّ ذِي حَقٍّ حَقَّهُ, that Allah had gave everyone, means of the heirs, his right. Okay, everyone got his right. So فَلَا وَصِيَّةَ لِوَارِثٍ, there is no wasiyah for a waris. You cannot bequest anything in a will for anyone who's going to inherit you. Okay, for not to exceed the 1/3, this is an instruction of the Prophet ﷺ to Sa'd ibn Abi Waqqas. He said, الثُّلُثُ وَالثُّلُثُ كَثِيرٌ, because Sa'd has the intention to donate half of his wealth. The Prophet ﷺ said, no, that is too much. He said, okay, 1/3. He said 1/3, and 1/3 is also too much. which means that it is the maximum. You cannot, no one can exceed 1/3 in his wasiya. Wallahu ta'ala alam. طيب, for the second part, now al-wasiya is one of the subdivisions of the contracts of charity, right? We said al-waqf is one subdivision, al-hadiyah, which is the gift, and we have al-wasiya, which is the will, and the fourth type or subdivision of contracts of charity is al-ariyah. Al-ariyah is lent items. Lent items or lending items to others. This is called al-ariyah. Al-ariyah is to permit someone to benefit from an object or a property that belongs to somebody else. Okay? And the one who's going to take the benefit of that object has to return it back to the owner afterwards or at a later time. Okay, for example, if someone lent a car from another brother, this is called ariyah because he has to return it back. Now, if he gave him the item and he did not ask him to give it back to him, this is considered to be as hiba or a gift. But if he give it to him to use it for some time and then return it back at a later time, this is called al-ariyah. It is similar to the gift, but the only difference is that it is only to be used or to benefit from for a specific period of time, and then to be returned to the owner of that object or that item. The conditions for lent items, of course, the lent item should be permissible to use, lawful to use in Islam. Anything which is haram to be used cannot be sold, cannot be lent, cannot be borrowed, cannot be dealt with in any type of transaction. So the object has to be permissible. It should be capable of being of giving benefit. This is also obvious. It should not be something that is consumable. So you cannot lend food, right? You give food, but you don't lend food because it will be consumable. And the lent item, as I said, it should be returned back after being used to the true owner. Okay, so it should not be something that is consumable. It should be something that remains after being used. Some related points to this issue of borrowing and lending items, that the borrower has to take better care of that borrowed item, even better than his own belongings. Okay, this is number one. Number two, the maintenance of the item while being used by the borrower is the responsibility of the borrower. Like if you lend a car from a brother, of course the maintenance of this car during the period that you are using it, it is on you, not on the type. The lender can restrict the area, like for example, as to the time. Okay, you can say, okay, I will lend you this item to be used for a month, for a week, for an hour. This one. To the place, you can say, okay, I will lend you this car, but don't use it in the highway. Use it in the city. Okay, this is an absolute right of the owner of the lent item. And as a borrower, of course, has to follow the restriction. Okay, the lender has the right anytime to ask back, the borrower to give him back the lent item. Anytime. Even if he give it to him for use for a month. If like a week later he decided to, and change his mind, he can ask for his item back, with one exception. Okay, if asking the borrower to give this item back will harm the borrower. Like for example, if Ali lent a truck from Muhammad, okay, so to move his furniture from one apartment to another apartment. Now while that truck is loaded in the middle of the highway, then Ali called him, I need my truck now. Okay, now if that is the case, or in such cases, he does not have the right to ask for his property now, because this will harm the borrower. Or if someone lent your phone, okay, and he's using the phone, and in the middle of the conversation you ask him to give me my phone back, okay, this is not acceptable. Okay, but other than that, he has the right to ask for his property anytime if it does not present any harm to the borrower. طيب, what if something happened to the borrowed item, like it is damaged, or anything happened to that, especially with ladies, when they borrowed gold from each other? What if that jewelry is stolen or lost? Is it the responsibility of the borrower or not? It depends. If the borrower took a better care for that item, but for any reason out of his control, that item was stolen or damaged, then it is not his responsibility. It is not his responsibility. Okay, so when you lend other people a property or anything, you have in your mind that anything might happen to that. Okay, but if you trust a person and you think he will take better care of your property, and you lend it to him, and something out of his control happened, then the borrower is not responsible for that loss, for that damage. Okay, but if it happened because of his shortcoming, he did not take good care of that property, of course he would bear the responsibility of that item. Wallahu ta'ala ajallu a'lam. This is in brief the last two subdivisions of the contract of charity, the wills and lent items. I'm going to conclude inshallah here. والله تعالى جل وعلا. سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك وصلى اللهم وسلم وبارك على محمد. جزاك الله خيرا.